Good morning or good afternoon, depending on where you are today. Thank you for coming to Unlocking the Value of Insurance, equipping policyholders in the construction industry with essential tools and knowledge. This is session 2. We're going to be discussing the claims process today. This is part 2 of a 3-part series. The third session will be on May 22nd. But fret not if you can't make the third session or you didn't make the first session. This also serves as a standalone webinar. So it's fine if you're just joining today. If you have any questions during the presentation, there's a Q&A box as part of the system on the right. If we will try to get it today, but if we don't, we'll follow up with you afterwards. So what will we be talking about today? We will be addressing what to do prior to and in the face of a loss or claim, how to handle a loss or claim, the reservation of rights letter and responding to insurers' requests for information, third-party claims and defense attorney invoices, how to respond to denial of coverage, and how to win negotiations with insurers. So we have a jam-packed session where we're going to move through it quickly. And again, we want this to be as interactive as possible, so feel free to put in some questions in the Q&A box. My name is Mikaela Whitman. I'm a partner in McGuireWoods LA office, and I do insurance recovery. So I only represent insurance policyholders against their insurance company. Simon?
Good morning, good afternoon. I'm Simon Hems. I'm a partner in the McGuireWoods London office. I also only act for policyholders. My experience is predominantly in the oil and gas and the offshore renewable sectors. So I'm coming to this today with a bit more international and London market perspective.
And hello, everyone. My name is Chris Thatch. I'm a partner in McGuireWoods Washington, D.C. office, and I am a commercial litigator. The vast majority of my practice over the last several years has been in the construction and infrastructure disputes space. And so I along with the other construction lawyers in our practice, represent owners, contractors, subs, et cetera, and a whole range of disputes related to all sorts of different large projects.
And following up on that, we just want to touch briefly on McGuireWoods and who we are and what we do specifically in insurance coverage and construction. On the insurance coverage side, we are exclusive policyholder attorneys, so we never represent the insurance company. We only ever represent the policyholder, usually corporate policyholders. And we handle all stages of insurance disputes in jurisdictions nationwide. So we will get involved when you're placing the policy with your broker, and determining how much coverage and what coverage you need. Work with the broker. We do policy reviews, and then putting in a notice of a claim. We can be involved then, and through the dispute with your insurance company, litigation, arbitration, mediations. Around the country and around the globe, as Simon's going to talk about more on the UK market.
And in terms of the construction practice of McGuireWoods, we have a large practice, around 30 or so lawyers all around the country and internationally as well. We represent the gamut, so we've done work for owners, developers, and contractors. And we, as I said before, we have represented folks in a whole range of industries. McGuireWoods is very strong in the energy space, so we've done a lot of energy infrastructure disputes work, but also manufacturing, sort of traditional infrastructure, mixed use and multifamily, residential, also commercial, and then a lot of even non-traditional infrastructure like aerospace and shipbuilding and things like that, where you oftentimes have construction issues, delay, schedule, et cetera. And then the way that we like to describe our practice is we kind of operate in 3 different buckets. We obviously do all the disputes work. So we handle litigation and large scale arbitrations, both domestically and internationally, when disputes actually end up in litigation. But we also do a fair amount of contract preparation and negotiation with our clients at the front end of projects, to help them draft their contracts and identify potential issues that might come up during that period. And then also after contract negotiation, once the contract is inked, we also do a lot of work with our clients during the project, which we often refer to as project and contract management. So effectively just working with the clients during the life cycle of the project to, again, help to mitigate risk, help to identify issues that may come up during the build, helping with things like responding to claims notices, which we'll talk about a lot today, dealing with change orders, things like that. All right, so we're going to jump in here and first talk about what to do prior to and in the face of a loss, claim, or lawsuit. And I will start first to talk generally just about the contracting phase. And this really applies both to construction generally, but also to specifically insurance recovery issues that you may come across during large infrastructure projects. And Mikaela and Simon can speak to this as well, but we believe very strongly that the first step here in dealing with claims is actually well before the claim. And so being involved at the front end of the project, at the contracting stage, helping to draft construction agreements and making sure they are complete and identifying and dealing with all the issues that may come up during the project. That's really the first step to an effective approach to dispute management. Good project documents, ones that are complete and fulsome and that are identifying all of the potential risk areas. If you've drafted well, then you're able to anticipate problems. I'm sure Mikaela and Simon as well can count on two hands a number of times when we've been involved in disputes at the back end and looked back and said, wow, if we had done something different in the way that contract was drafted or the way that we responded to that claims notice, then we may be in a completely different situation here with respect to the claims. So being able to anticipate problems, being able to allocate risk strategically in the way that the contract is drafted, and providing for efficient and successful resolution of disputes, hopefully long before the dispute actually becomes a claim. And so some things just to remember, and these are tips that apply to insurance recovery claims specifically, but also just as much to the general construction projects and how to avoid claims. The first thing that we tell clients often is to maintain clear and contemporaneous documentation. And we'll talk a lot about that throughout this presentation today in terms of keeping track of policies, keeping track of claims notices, keeping track of requests for information. Really your first step in making sure that you are managing risk appropriately and preparing yourself either to avoid a claim or to position yourself successfully to deal with claims is to make sure that you're documenting everything. And whether that's the lawyers who were involved in the project, both either in-house counsel or outside counsel, or it's a project member team, a group of engineers or construction project managers who have a specific role on the team and as part of the project to help to maintain the documentation. It's incredibly helpful, obviously, just to maintain a successful project and to keep track of things and to keep track of deadlines. But it's also incredibly useful if you do end up down the road in a claim and you have the evidence, the actual documentation itself to help you tell your story and tell your narrative when you're actually having to defend or pursue claims down the road. The second thing we try to encourage clients in projects like this is to respond thoughtfully to all notices and correspondence that come across your desk during the project. And again, this is something we'll talk about as well in more detail in a few minutes. But I'm sure most of you who are attending this webinar have been involved in major infrastructure projects, multi-billion-dollar projects over the course of several years. There is a lot of documentation that comes across your desk. There are notices from subcontractors, notices from general contractor, from owners. There are questions about the schedule. There are notices that are coming across when schedule is thrown off course, when there are potential delays, when there are cost overruns, et cetera. it's extremely important, and also with respect to insurance issues, to respond to those notices and that correspondence not only thoughtfully but promptly and completely. It is a lawyer's best friend, frankly, in a litigation or dispute situation, is someone on the other side who, frankly, has not responded to a whole host of questions, problem notices, correspondence. It is very easy to argue waiver and to argue that the other side has accepted or agreed to take a certain step if there is no thoughtful and complete response to issues that come up during the project. So extremely important. The third thing we like to tell folks is follow the contract. The contract is effectively your Bible during these projects. Obviously there's a lot in the contract that you probably will never look at again once it's been drafted and inked. But there are also parts of the contract that are extremely important to the project management process. Whether it's the claims process. Obviously, usually there is a very detailed and step-by-step claims process that is identified in the contract. There are specific requirements for how notice is meant to be given and received and responded to. There are all sorts of, obviously the scope of work is extremely important, but on the insurance side as well, and Mikaela and Simon will talk more about this, but there are also a lot of details around how insurance claims are meant to be handled. Those are all things that the folks who are involved in the construction project need to know. Too often these contracts, they're hundreds and hundreds of pages long, and they end up getting shoved in a drawer somewhere, never to see the light of day again. The reality is it's extremely important to have that contract accessible and to understand what those provisions say and what they dictate in terms of claims, so that you're prepared when those notices do come across your desk. And then the fourth thing that we talk about a lot with our clients, and we have an asterisk here next to adhere to schedules, because we can all appreciate and understand that that's usually easier said than done, especially on these major multi-step and multi-year projects. Schedules often go off track. There's often a lot of discussion amongst the shareholders about schedule and potential delays and et cetera. But the easiest way to avoid a construction claim is to adhere to the schedule. And if the schedule is not adhered to closely, to make sure, again, you are papering every decision that is made by either side with respect to schedule. So anytime there is a potential delay, anytime there is a claim for delay, anytime there is any suggestion that a deadline hasn't been met or may not be met going forward, extremely important to do everything you can to keep the schedule on track, but if not, to make sure you're papering every decision that's made regarding the schedule.
Thanks, Chris. And just sort of picking up on at the end of the contract subject set of slides. This one, obviously, all construction contracts have an insuring obligation, and this slide sets out some of the key points that tend to go into it. Things to particularly think about are a sort of situation where actually what you're concerned about is not necessarily your own policy. And this is a situation, for example, where an employer effectively requires his contractor to place the insurance, but to be named as a co-insured, waiver of subrogation, the sort of standard provisions you're used to seeing. But there are nevertheless things to think about around that, and which can be addressed more easily at the point of contract rather than later on when an issue has arisen. The first is simply getting information. I would advise trying to include a right to actually receive policy information. Otherwise, all you might find you get is a certificate, and all that might do is confirm existence of cover and some key items such as limits and deductibles and things like that. But you might not actually have much better information about what cover you have. And if you can go so far as to get assurances that you're going to get notices of developments with the policy, like endorsements over time, then even better. But there are some other little nasty issues that aren't always thought about at the point of contract that are worth addressing in the insuring clause. The first is a right to claim. Just because you're a co-assured, it doesn't mean to say you necessarily have a right to claim if you're the one suffering the loss, and always isn't always necessarily written into your contracts. Second is make sure you have a right to be paid. Consider who's going to be the loss payee under a policy where you are a co-assured. You ideally would at least share the rights in that where you have suffered the loss. Also, pay attention to exactly what the scope of the cover you're asking for is. So it's very good to define things in fairly general terms, like you might need a liability cover or a property damage cover or something like that. But what type of cover have you got? If it's all risks, what are the exclusions and how likely they're going to be to apply? And also, if you're asking somebody else to place it, do they even have the capacity to cover your interests? And I'll give an example of something like the sort of Gulf Horizon type scenario there, where BP thought they had cover under Transocean's policies because they were a co-assured, and actually they didn't, because all Transocean was covering were their own liabilities and not BP's. So it's a trap for the unwary. Also, try and understand, and this is a comment maybe more from an international perspective, but think about what the consequences are going to be if you have a claim that becomes contentious. Particularly, a lot of jurisdictions around the world, their local laws require cover to be placed into the local market first. And even if you are sensible enough to then require that to be reinsured, it's quite often market practice, especially in London, that all they do is adopt the law and jurisdiction of the direct policy. And I'll give you an example of a client of mine that's been quite nastily caught out in recent years is where they subcontracted the insuring obligation, and they now face themselves potentially having to sue the London market in a Moscow court in Russia under Russian law. So a little knowledge about the practices in the jurisdiction where you're going to be operating can save a lot of time and cost later on. So this slide just sort of brings together some points to bear in mind in terms of insurance aspects. First of all, the difficulty of point one is where there are relevant for policies played by other parties I've just been discussing. It's much easier to gather your policies if you've secured all of them at the point of contract. Trying to get a policy wording after a potential claim arises and where you're not the name assured or necessarily responsible for the premium is potentially challenging. Couple of points on point two in this slide. First, to establish whether your particular loss is covered at all. Second, to avoid presenting your claim under the wrong policy. That first could risk your claim being timed out under the correct policy. It also potentially helps the insurers from denying the claim if they're going to say that actually your first attempt was the right policy to present your claim under, or that other policy should be paying first, and all they're obliged to pay is anything on top. And point three, in terms of don't assuming there is no coverage or that there are exclusions, although it is on you to prove a claim, it's on the defendants to prove an exclusion, i.e. the insurers. So let them make the running on that, and don't make assumptions. See how they react. They may not have thought of something, or they may be making something up that just doesn't work. Nevertheless, do be mindful of exclusions that could be applicable. You don't want to be presenting your claim in terms of the language of exclusions and potentially opening a door that shouldn't be. And then in terms of asserting the claim itself, lay it out as you want to, and let your insurers explain why there isn't cover if they consider that to be the case. Don't give up on claims. And if in doubt, speak to coverage counsel or your broker. One point to note about the brokers, though, is they will walk a fine line between your interest and the markets. They're not lawyers, so their advice is generally going to be based on market practice and how markets like to read the wording. And that might not reflect the legal position. So there is merit in getting coverage counsel involved early from the point of view of assessing coverage, at least on larger claims. On point five, denying the claim on the basis of late notification is an easy win for insurers, and don't give them that opportunity. Be aware of what the notice requirements are, both as to time and as to content, and especially wordings that call for notification of events or circumstances rather than actual loss. the former tends to arise much sooner than the latter in many cases. Also beware wordings that refer to vaguer concepts such as soon as possible rather than a definite time limit. It gives you some leeway perhaps, but it's difficult to know how much at times, and it's ripe for an argument if you are seen to be dragging your feet a little bit. Best practice is to give notice the moment you're aware of something that's happened that might cause you loss. You don't need to provide much detail in a first notice necessarily. The important thing is to ensure that insurers have it on their radar and have been notified. The point at which events have occurred are likely to result in loss and possible claim is the time to consider appointing coverage counsel. It may feel a bit early at times and a bit unnecessary, but a proper legal analysis early on is usually better than market interpretation of the policy. And coverage counsel can often advise on how to present the claim in a proper form and according with the policy, as well as create a privileged environment to investigate and advise from an early time.
Simon, one thing I wanted to jump in there before you leave that slide, I just wanted to emphasize what you've been saying about asking for all of the policies in the contract itself. I'm dealing with an issue right now where I just have 15 certificates of insurance, and it tells me nothing about the actual coverage. And there was no requirement in the contract that they had to give them, the owner had to give any of the policies. We don't have any of the policies. I don't know where to give notice. I don't know how much coverage there is. I don't know any of the terms. So it's really important, if the other side will agree to it, to put it in the contract that they have to give you the full policies and not just the certificates of insurance.
Yeah, absolutely. I've got a similar situation at the moment where all we had was the certificate until actually weeks even after we'd issued litigation. And one of the arguments we're having to run is that the certificate is effectively a collateral contract in its own right, and that is getting technically difficult. Having the policy wording would have made life so much easier. So, moving on to the point at which something's happened, a loss or a claim is in the offing. There's a simple and fundamental point here. Anyone can bring a claim, and many of you will be familiar with these sort of common heads of claim: delays, payment disputes, change conditions, site conditions, damage claims, that sort of thing. Books can be written on the reasons claims arise during construction projects and why they become litigious. The sheer complexity of them often means that parties can't unpick the various causation strands on their own. But one thing, in my experience, I think I'd highlight, time and again, one of the underlying problems I see, and it goes to a point Chris was mentioning about shutting the contract to the drawer, is that one party has simply failed to follow the requirements in the construction contract in some way, usually a procedural matter like a time limit or content that needs to go into submissions or something like that. I raise that simply to make the point that that doesn't just necessarily give you trouble when it comes to resolving the issue at a contract level, but it also is fodder for insurers who want to give you trouble in terms of presenting a claim. And Chris, I don't know if you wanted to loop back in on that point with any experience, but I just raise it as something that sort of comes back to something you were saying.
Yep. No, I appreciate that, Simon. And I do think, one thing it struck me from your comment is that, as much as we do deal with claims of delay, schedule, cost overruns, et cetera, sometimes you're dealing with, defects in work. Sometimes you're dealing with design issues. I mean, more often than not, I think this is part of what you were getting at, but if not, this is what I took from it anyway. Oftentimes these disputes are literally around procedural or process issues that stem from the contract that just have not been followed appropriately. So oftentimes it's not even so much a substantive issue. It's just an issue of, well, you missed these X, Y, and Z steps, and therefore that's what has gotten us here to this point. And those are all, I mean, if you're involving litigation counsel early on in the project, hopefully those are often issues that can be addressed in the contract drafting and then can also be addressed during the project, again, with counsel's help when those notices, et cetera, are coming across the desk.
Yeah, absolutely, and that sort of more procedural point is going to be a bit of a theme, I think, as we move on to claims handling under the policies as well. The first point of which is giving notice. I've touched on this already, but it's maybe less obvious sometimes than you might think in terms of how to notify an insurance claim. Quite often, the policy will have a notification clause. It will identify exactly who needs to be given notice to, and you need to ensure that you give notice to the party named in the policy or the slip, depending on what you have. And quite often, you may not have that information. And this goes back to the point that Mikaela just emphasised in terms of all you have is the certificate. That won't give you any claims notification information. Quite often, the policy might say that you have to tell the broker, but don't assume that. It might be a lead insurer directly. It might even be a law firm or some other claims handling agent. But if notice is not given specifically to the right party that the policy requires, then you can expect the insurers are going to take that point and use it as a basis to try and say you're out of time if and when you do get your notice right. Also think about whether this is the only policy you need to be giving notice over, not just necessarily subject matter, but bearing in mind the scale of whatever loss is on the horizon. Think about the structure of the insurance. Are there excess layers? Notice to insurers at the bottom alone might not be sufficient. What are the requirements in the excess cover, or is it different? Is it a different party? And make sure you comply with those as well. If you're not the named assured, and there are doubts about whether you have a right to claim, you may need to get the named insured to provide that notice as well. So make sure it's coming from the right person as well as being sent to the right person. Also, don't assume that an actual loss needs to have occurred before you give notice. The wording of exactly what the notice requirement wants to hear about can often be couched in terms of events or occurrences that might give rise to a claim rather than notice of an actual loss that has been suffered. That means notice has to be given much earlier and before you really understand exactly what the impact on you might be. Notices can be couched in terms of a potential loss. They should be updated as the loss and the nature of the crime crystallizes. But there are also traps for the unwary there in terms of how you describe what you're putting in on notice if you don't know an awful lot about how things are going to unfold in due course. And I'll come back to that in a little bit. There'll often be a time period stated for when notice needs to be given. That will sometimes be put in terms of a condition precedent to payment. Make sure you comply with those notice periods. Where there can be a difficulty is if the period just refers to as soon as possible or something like that. I would take that as literally as you can and give notice as immediately as you can after becoming aware. And even if you don't become aware of circumstances until maybe quite some time after it proves that they've occurred, still give notice straight away and make the insurers have the argument with you about notice. If it was genuinely the first time you became aware of it, then that's not necessarily any kind of breach of the notice provision. It might also be worth having a look at any claims control clauses you have in your policy. This is the bit where insurers reserve the right to appoint things like loss adjusters and investigators and other people they need. And if you can, in your notice, call on them to exercise their rights there, it might encourage them to engage. It might also prejudice their ability to deny costs that you have to incur if they do nothing. And then also have in mind, if you've had to issue, particularly on long-running projects, any earlier notices, is this notice you're looking at now a completely new event or a continuation of something that has existed previously? And if it's the latter, be careful that it doesn't have the effect of breaking the chain of causation or effectively stopping the clock. Or restarting the clock, which could be even worse in terms of the timeliness of giving notice of a claim. So also just have in mind this in the context of the project as a whole and what's gone before. And in this slide, we've just sort of put those points together in a sort of process to have in mind, and this is something probably useful to have handy as events and cover in terms of going about giving notice, the things to think about before you do it, and preparing it. And it goes without saying, I think, but at any point you find yourself in this situation and you find yourself not being entirely clear where to go and wanting some help, then it's always worth asking. And then we get the responses. Once you've given your notice in, and I noticed the slide, or some of the slide coming up, that there may be actual specified time periods in parts of the US in terms of responding to a notice of claim. It tends to be less the issue in the London market, but there is an expectation that they will respond within a reasonable time and as soon as possible. And depending on the scale of the claim, a reasonable time is a rather elastic concept. But there tend to be three types of response you'll get, which will be yes, no, or maybe, or as we have here, an acceptance, a reservation, or a denial. Now, in my experience, the expectation of the claims arising out of a construction project, particularly ones of more complex nature, should be that you should expect to get a maybe, or the reservation of rights situation in the second point of this slide. The tone of the reservation often suggests insurers are suspicious of the claim and are doubtful that they will have to pay it, and may even go so far as to identify the issues they have identified with coverage, although that may not ultimately prove to be the case. But the reason for that tends to be because notices have to be given so early in the process after having discovering relevant events, and often there just isn't enough information available for an insurer to take a view. Or the causation scenario is too complicated to take a view without careful investigation and the involvement of loss adjusters or technical and forensic experts that may need to get involved. Unfortunately, a response in which insurers reserve their rights also tends to be the one most fraught with difficulty and full of traps for the unwary insured. And I'll come on to discuss that in the next few slides. What I would say here, though, is that insurers' reservations tend to fall into two broad categories. First is where they've highlighted a number of often quite technical points as to why an insured peril is not engaged. The second is where they identify failures relating to process within the policy itself, such as whether you have a right to claim, applicable deductibles. The type of response they give now may well set the tone for what happens next. A coverage response in terms of a peril is not engaged might mean insurers are still going to go through the investigative process to work out whether they're right. It may just be a suspicion. There's potentially a constructive discussion that can be had with the insurers where a factual scenario is still evolving and their main concern is whether or not a peril is actually in play here. The second type of response, which is a more technical one under the mechanics of the policy as to why they shouldn't claim, might be more relevant to insurers already having decided they don't want to pay or they want to deny cover. All of that means that actually outright denials of claims right from the start are relatively uncommon, and there may be stuff read into that. If you get one, consider whether there might be a wider context behind that. As contentious as insurers can be, they also don't like being named as losers in judgments or the publicity that goes with that. Quite often, a straight denial might arise because of some other supervening event that is actually tying together a lot of claims to make their exposure very large. So, for example, a hurricane or a terrorist event or something like that can create that sort of situation. So even if your own claim doesn't look particularly significant, their total exposure under the types of policy they provided and which are affected by that event could be a very, very large exposure, in which case a straight denial might be a first filter from the insurers to try and weed out anyone who isn't very serious about pursuing their claim, to shave off what their ultimate liability might be. And in that context, it's not even unheard of, and certainly in the London market, to allow themselves to get sued. It's effectively creates them a window to raise funds. And it's not unusual that if you hold your ground, there's very often a flurry of settlements just before trial or even during trial because of the scale of the issue. So in a weird sort of way, an outright denial of a claim may be more positive than immediately might be obvious. That then brings us on to the question of the reservation of rights letter. and how to deal with insurers' requests for information in a situation where it may feel like they're, and in fact, they may be being adverse to your interests and the claim. In terms of what the letter is, claims or events that could lead to a claim generally have to be notified pretty quickly and often well before a full understanding of the event and causation has been developed. And insurers are going to be wary of doing anything too soon or that commits them to paying a claim. And that includes the risk of their staying silent in the face of a notice. So a standard response is a reservation of their rights. And they ideally will go on to set out what some of their concerns or the reasons for their reservations are. That can include things like an underdeveloped understanding of the facts, a view that an insured peril doesn't apply, that there may be some policy exclusions in play, which they still need to establish the facts to understand. There may be particular heads of loss that they don't think are covered. They may say that losses exceed the cover limits, or that some other policy should be paying, or that there's an aggregate limit that will be exceeded, or maybe even has been exceeded already because of previous claims. They may try and point to some other breach of the cover by the assured, or even, and I'll come back to this one again, particularly where you're not the named insured, whether you have a right to claim, whether somebody else should be pushing this, and possibly not a party with the insured interest for the particular loss, which creates a more complicated situation. It may also be a way, the reservation letter, it may also be a way of insurers testing the resolve of their insured policyholders and how serious they are about pursuing their claim. Many assureds may well be put off by the prospect of the time it would take to recover money and having to spend money on lawyers in order to get their indemnity. And again, pushing back and showing some resolve can achieve some results on occasion if the insurers are just trying to get out of an exposure rather than being holding strong views that they don't have an obligation to indemnify. So on its face,
sorry, I just wanted to jump in there. Just because this always surprises me on claims when a policyholder gets a denial and we write a letter and the insurance company folds. And it's always, even though I'm like, oh, that's exactly what was supposed to happen, I'm always surprised because it just shows the insurance company had no basis for that denial whatsoever. They were just sending a reservation of rights letter to try to get out of the claim. And as soon as they get a letter from Coverage Counsel, they folded. So just be, as Simon's pointing out very rightly, be mindful of whether there's even any coverage defense there.
Yeah, absolutely. It's almost like, I mean, they rely, it's human nature that most people don't really like jumping through hoops and making life more difficult for themselves than they have to. And this applies as much to insurers and testing how willing their insureds are to pursue a claim. And yeah, you're right, Mikaela. It's amazing how many people give up when they just get a straight no, and pushing back can achieve a lot. So on its face, the reservation is just the insurers taking a holding pattern. There can be other commercial and legal underpinnings that it's sometimes worth having in mind. On one level, the reservation creates the space that probably all parties need to investigate a claim properly, including gathering of evidence, inspections, testing, whatever it might be. It's also the first issue in which the interests of the insured and the insurers can start to diverge. If insurers are investigating from the perspective of consolidating a position of no coverage versus an insured who clearly wants to build up a factual picture that establishes there is coverage. So that leads up to a point about being aware of appointments the insurers might be making in terms of loss adjusters and other investigators and things like that, and trying to be involved in that process. They should be willing to share information and reports that are generated, but more often than not, if you don't ask, they won't give. And if you're not involved in things like the instruction process or taking up rights to share in inspections and things like that, then you may not. That questions might be raised about the objectivity of the result that comes out at the end of it. And these are things that you should be insurers should be expecting you to ask about and should be willing to give. Just moving on. That comes on to how to respond, well, whether to respond and then how to respond. The first question is relatively easy, in that it's an unusual case where you shouldn't respond to a reservation of rights letter. How to respond is the bit where a bit more care is required, and there is a line to be walked between the obligation to provide information to insurers, so long as coverage hasn't been formally denied, and providing with so much information that it actually helps in their efforts, potentially to build a case against you. A few fundamentals to have in mind. Do you know anything about who's been involved in preparing insurer's reservation, even if it's on their letterhead? They may have told you, or you may have an idea that they have got counsel working behind the scenes. That might be telling of their attitude. Be careful about your own internal paper trail that's being created after an event has occurred. Have in mind the likelihood, worst case scenario, that it could get disclosed in litigation later. And that, from that point of view, control who internally is talking about the claim and the loss, and differentiate between gathering information and people giving opinions about what to do with that information, what it means. Especially try to avoid anyone doing the latter, other than perhaps if asked by a legal team to allow them to advise, which would lead to a more privileged environment. Ideally, have a single point of contact with insurers or the brokers, depending on what the flow of correspondence is. You don't want multiple people within your organization having different lines of communication. It's much harder to control the narrative and who's saying what and what information is being shared. Consider when you do get requests for information from insurers, as they will do, be careful to consider whether the requests can be answered, but also should they be answered. And I'll come back to that point in a minute. And also, as part of that, keep in mind the context behind the request for information. What have they said about their position in coverage, which should inform to some extent particular points they're interested in developing, and if their requests for information are focused in a certain direction. Also keep in mind what is still not known about the events giving rise to loss or a potential claim, and other steps that still need to be taken in terms of investigation, etc. Ideally, if you can, withhold information for now that might prejudge an outcome or which could be used out of context without a developed investigation. Otherwise, ensure it's provided with the right covering message and reservations about what it means and how it should be used. This is usually the point at which coverage counsel start to hover over the horizon and get involved. I've sort of made the case for getting us involved a bit earlier, but I think this is the point where particular care is required. There are a lot of potential traps for insureds responding to requests for information where it's in the context of a reservation of rights, and there are potential serious consequences of getting it wrong. Involving coverage counsel has the advantage of being able to create material and discuss the claim in a privileged environment. So material generated as part of that should not then become disclosable later on. And that is not something to be overlooked. I think it's no small thing. And then some tips on responding to reservation of rights letters. I'm not just going to read these out. I think they're fairly largely self-explanatory. I would add one, that if you are required to correspond through the broker, do what you can to make sure that they are passing on your messages verbatim, that they're passing them on with any attachments and supporting materials and not interpreting those messages for themselves, or just giving summaries. And likewise, make sure you're getting the actual word-for-word messages coming back from insurers as well. 2 points in the middle of this that I'd particularly focus on. First is compliance with reasonable requests. For so long as insurers have not positively denied cover, a reservation should be treated as a reservation applying to the proper investigation and claim by insurers. That entitles them to make requests for information, but only in accordance with whatever provisions entitle them to do that under the policy. You might see an obligation to provide all demands or notices or summons, or for the insured to, and I quote, render such further information and assistance as insurers may reasonably require. The emphasis there is on what is reasonable. It's not a blank check for insurers to demand everything they want. The first point is a critical look at whether what is being asked for is relevant. If not, ask why they need to see it. The second point is whether there are legitimate grounds for withholding the information, but maybe because it's privileged or it's disproportionate. And certainly from an English market point of view, that would be a test as to whether there is something reasonable. If it's wildly disproportionate to the time, effort, cost, or purpose, then it's probably not something you need to comply with. Just skip ahead. The main point I think to say from this slide in terms of requests for information, these would be certainly 5 of the key categories to be wary of about handing over. Context is everything, and it will quite often depend on the type of cover that's in play here, but keeping privilege and giving away as little as possible is definitely part of the game, and these are particular categories of information to be wary of and to get advice on before just handing it all over. And then waiver of privilege. I'm conscious that the position in England may be a little different to the position in the US, so I'm going to maybe just start with a few basics from my perspective in terms of waiver of privilege, and then hand over to Mikaela to perhaps highlight any differences that you should be aware of from a US perspective. So far as, say, a claim that would be subject to English law or in the English High Court, privilege attaches automatically. It's not something you need to label. And indeed, labeling something that isn't privileged doesn't create privilege. Particular point to bear in mind is just because you're corresponding with your lawyer doesn't mean privilege attaches. It only arises in cases where the communication is for the purpose of giving legal advice or when in contemplation of legal proceedings. It's only between the client and its lawyer, but even then, it's narrower than that. It's only between the particular principals who are authorized to give instructions. So, for example, my correspondence with a general counsel would naturally attach privilege, but if he then passes it on to, say, a project manager, that would be a waiver of privilege because I don't take instructions and would not treat that project manager as my client. So it's a fairly narrow scope in terms of the flow of communication. So the first point in this slide is undoubtedly true, but in terms of waiver by making a voluntary disclosure, but there are differences to privilege, I think, between different legal systems, particularly perhaps between English and the US. The reality under the English system is that if you have to share information with the insurers, then the only real way to protect it is so long as your interests are aligned, in which case you can rely on the doctrine of common interest privilege. And in that context, you might, whilst you're still friends, be able to reach agreement that upon that common interest coming to end, then each party will return or dispose of any privileged information they have. But otherwise, confidentiality agreements, NDAs, anything like that, they're not necessarily going to protect you. That said, that's possibly quite a scary view of privilege in an English perspective, and maybe Kayla can provide some reassurance that things are better in the US. So I'll pass back to you.
Unfortunately, I was just going to say it's very similar in the US in that, you know, you're only going to have if you have a common interest with your insurance company, that's when you would have a privilege with them to share information. The problem is, do you have a common interest? And that gets back to the reservation of rights letter of if they accept coverage without any, reservations, that usually means there's a common interest there and you can share information with the insurance company. If they deny coverage, that's a red flag. There's no common interest there at all. And then when you hit the gray area, which is the reservation of rights letter, which Simon talked about, it's questionable whether there is a common interest. And it's going to vary by jurisdiction and what law applies to that common interest. Sometimes, as Simon mentioned about the agreements, we will do a common interest agreement to try to protect the information when there's a reservation of rights in place. However, that's not ironclad. Again, it's going to depend on jurisdiction and if it's challenged. And sometimes underlying plaintiffs will be very aggressive and will try to challenge that common interest agreement to get at the information that you've exchanged with your defense counsel. Okay, and I'll just go through some of these tips because Simon mentioned the first one, using prominent designations of privilege if applicable. They don't, as Simon said, they don't necessarily mean it's privileged, so don't overuse it. Some people just put, attorney-client privileged on everything to try to, which can be good and helpful, but it also doesn't mean it's privileged. So you want to look at the document itself and make sure it's actually privileged and don't overuse it. I've seen courts get really frustrated with individuals for overusing the designation. Limit recipients of privileged information. If the defense counsel that's appointed by the insurance company asks for it, send it to him. Don't send it to the claims handler and the broker as well. Send it only to the defense counsel who's defending you. Start new email chains when appropriate. I can't tell you how many times emails get forwarded or forwarded to the broker, for instance, forwarded to another party, and the privilege is waived. If in doubt, pick up the phone. I know people like to text now, but the phone is still there. Pick it up, especially when communicating with the broker. We're not going to get into broker privilege issues in particular today, but that is often an issue of when there is privilege with your broker. So just pick up the phone if in doubt. Okay, I am moving on. Tips for responding to requests for information. And these are practical things that you should be considering when the insurance company asks for information. And they can be asking for information when there's a reservation of rights in place or when they've agreed to defend and they've appointed defense counsel or paying defense counsel. So since they're agreeing to defend, only provide information related to the defense of the action. If they're asking for things outside of the defense, this should raise a red flag. It often will indicate that the insurance company is looking for ways to deny coverage going forward and turn that reservation of rights, if there is one in place, to a denial. So they'll ask things like, when did you first become aware of the claim? Does the claim relate back to an earlier claim? Did you provide notice of the claim to anyone else? These should raise red flags in your mind that they're not just asking about the defense. As I said earlier, if defense counsel has been appointed, only provide information to the defense counsel. It remains privileged. Provide or direct insurers to publicly available documents. This one's important because often the insurance company will ask for all underlying pleadings, motions, everything that's been filed, and it's a huge burden to gather all those. If they're publicly available, simply direct the insurance company to those documents. It's an easy way for them to get them and takes the burden off your plate. Stick to factual information. Don't give miscellaneous information. This is not when you're providing information to the insurance company, it's not an opportunity to prove your underlying case and why you're going to win your underlying case. Just provide information that's requested and pertinent to the defense of your action. Okay, this is when they're asking for too much information. The insurance company is just burdening you with all these information requests. Remember that the duty to respond and provide information is not an unreasonable burden or duty to respond. Consider the status of the insurer's coverage position, if reservation of rights has been issued, and if coverage counsel should be involved. If you feel like you're being taken advantage of and harassed by the request for information, don't just sit back and take it. This is a good one. Keep in mind that the insurer is represented by coverage counsel in its communications and meeting. Appearance may be created that the meeting is not pursuant to a common interest. So oftentimes the insurance company will say, okay, we'll defend under a reservation of rights and we'll appoint defense counsel, but we also have coverage counsel involved. If coverage counsel is sitting in, coverage counsel from defense or from your side on those meetings, it can break the common interest. So you want to be aware of who's on those meetings, and not having coverage counsel on is an easy way to show that there was a common interest there. Okay, I'm going to skip ahead to defense attorney invoices because I'm going to cover the last slide here. Okay. This is when the insurance company has said they will appoint defense counsel. And either they will say they want to use their firm and their attorney, or they will pay for your firm that you want to use. So often disputes will arise developing around the scope of the insurer's duty to pay for the defense, who is selected, what are the reasonableness of rates. This is just a common thing that arises. So you want to know, first off, what your insurance policy says about the defense duty, rates, and consent needed to hire defense counsel and or incur defense costs. For instance, your policy could say that you can't hire defense counsel without consent of the insurance company. You go and hire him before you ask for consent. The insurance company comes back and says, we will not pay for him. We're not going to pay anything because you breached a term of the contract. So you want to know early on what's in there, what you need to ask consent for. I always say asking consent for upfront is much easier, even if they deny, because you have it in writing that you did what you're supposed to do. And if they say we don't want to use that person, you can still use that person. There's other arguments to make for why you want to use that person, but you at least ask for consent. So they can't say you breached that term right off the bat. Hourly rates, often a point of contention because your attorney will likely charge higher rates than what the insurance company is willing to pay. So there's often a negotiation of trying to get those rates up. It will depend on jurisdiction, the insurance company, how much higher your rates are. And one of the things I always say is know what the law is in your jurisdiction on reasonable rates. Know what the standard is. Know how to make an effective argument to the insurance company to get those higher rates. Know what lawyers are charging in that area and in similar cases. Okay, this is when you are submitting the defense counsel invoices to the insurance company. Oftentimes, the insurance company will not pay the full invoice. They will have cuts. They will say things are unreasonable. So these are some tips to get the most money out of those invoices, to keep those reductions as limited as possible. Prohibit block billing is an easy one. I know some law firms insist on doing it, but insurance companies typically will not pay for block billing. They want to see itemized line item time entries. Use descriptive time entries. I have an example in there of a way to just tweak a time entry so that you can really see what's there. Usually if you put in regarding, an insurance company will flag it as, oh, we have more information about the claim. So regarding X is an easy way for insurance companies to know what's going on. Avoid inconsistent time entries. So that means two attorneys attend the same meeting, but one bills 5 hours and one bills 6 hours. That's an inconsistent time entry. Multiple attorneys performing the same work. Insurance companies will typically not pay for that. So you want to, I'm not saying they should, oftentimes two attorneys will be doing debt prep, but you want to tweak that description so it doesn't look like the exact same thing. Provide backup and support for expenses. That's an easy one. Just gather the backup. They're going to ask for it, so you know it's coming. Redact all the information. Don't just black it out. Regularly follow up. Even if they're not asking for additional information, you should set a little tickler for at least once a month, once every 2 months, depending on how long the project's going on. Even if it's just an update of nothing's going on, providing you an update will keep you updated going forward. As Simon was saying early on, and Chris, setting the record at the beginning and having the documentation is going to help you a lot on the back end if you have a dispute with your insurer, because you're going to have all the documents saying, I did everything I was supposed to do along the way. Okay. How to respond to a denial of coverage. So this is when there's no reservation of rights, they've just denied right out. So you have to decide, do I want to respond now or later? And if I don't respond, am I waiving any rights by not responding? Should especially be careful of any contractual limitations, time to file suit against the insurance company, and any ADR provisions in the policy. A denial of coverage ends their obligation. So any obligation you have to provide them information after they deny coverage ends there. So often they will an insurance company will keep sending you requests for information, just so you know you do not have to respond to that once they have denied coverage. And when they deny, you should also consider coverage litigation if you want to pursue that. and what jurisdiction you would have to pursue that in. Okay, last slide. Coverage litigation. Always be sensitive to getting jumped by the insurer. Insurance disputes are governed largely in the states by what state law applies. And so insurance companies will try to get the most favorable law they can over any dispute. So they might jump you in another jurisdiction to get that law. So you must be constantly thinking about what law is most favorable to me. And if there's coverage litigation, what form do I want to be in? Have to be mindful of time traps and deadlines. There are strict statute of limitation periods that you can sue an insurance company, and they vary by state. And this is strategic of how you want to approach the coverage litigation. My biggest advice here is keep it on your terms so that they're not setting the stage, jumping you somewhere else, getting ahead of you. You want to be in the driver's seat. And that is the end of our session. Thank you very much for coming. And I see there were 2 questions in the Q&A box. We will follow up with those and get your email from the list. Thank you.